My name is Manuelita Cody. I am the president of the North American Chilean Chamber of Commerce. On behalf of the directors and the members of the chamber, we thank you for joining us this afternoon. We are having a great webinar on cross-border reorganization in Chapter 11, a subject that it is of interest to many, as we have seen with our multiple interested inscribers. I want to thank very specially our speakers today for giving their time and their expertise in support of this great activity. Ronald Silverman, Robert Wagstaff, Juan Goldenberg. It is a pleasure for me to introduce the moderator for today, which is Guillermo Morales, who is also a director and a member of the chamber. So we're very, very pleased, and thank you, Guillermo, for helping us organize this. Guillermo Morales Errázuriz is a founding partner of Morales y Besa, a law firm with offices in Santiago, Chile. He specializes in advising domestic and international corporations and financial institutions in corporate finance, mergers and acquisitions, and matters affecting corporate policy and strategy. He graduated from Universidad de Chile in 1985, was awarded a Fulbright scholarship, and graduated from the School of Law of the University of Chicago. He worked as an international associate with White & Case LLP, a law firm here in New York, and served as the Secretary of Inter-American Affairs Committee of the Association of the Bar of the City of New York. Since 1997 to date, Mr. Morales is the honorary legal advisor to Her British Majesty Ambassador in Santiago, and his memberships include the International Affairs Committee of the Directors of the British Chilean Chamber of Commerce, the Board of Advisors of Fundación Pro Bono, the Board of Directors of Make-A-Wish Foundation, a wonderful organization that raises funds to provide wishes to children in severe health conditions, and the Bar Association of Chile. As I mentioned before, he's also on the board of our chamber. We welcome you, Guillermo. Thank you again. Before I give Guillermo the floor, I will just ask the audience to keep your microphones on mute. We'll try to do it for you as much as we can. This way we give a chance to all the speakers to be heard very clearly. If there are any questions that you have, you can put them in the chat, and we'll be glad to answer them for you. Thank you so much. And Guillermo, you have the floor.
Guillermo, we can hear you.
Is that okay now?
Yeah.
Oh, thank you. Thank you, Manuelita, for that. I'm just starting to learn to use this new technologies, and I'm not so very good at it. So I wanted to first and foremost thank you, Manuelita, and thanks Claudia and Rodrigo for putting at the chamber for putting this together. It's been a terrific effort, and I think we owe you so much gratitude for all the organization and planning. I would like to turn on to our panelists and give you a brief introduction of first Ron Silverman. He is the co-head of Hogan and Lovells U.S. Business Restructuring and Insolvency Practice Group. He has practiced for more than 25 years and represents debtors, lenders, bondholders, investors, and corporations involved in restructurings, rescue financings, distressed M&A, and insolvencies. The diverse range of Ron's experience spans the spectrum of sectors, including transportation, aviation, shipping, media, manufacturing, real estate, mining, power, oil and gas, and many others. Ron's work often involves cross-border matters covering all regions of the globe. A primary area of focus is Latin America, where he has worked on some of the region's most significant recent matters, including the $19 billion restructuring of Ecuador's debt, the $6 billion restructuring of Mexico's City Airport Trust's bond issuances, and the 250 million Chapter 15 of Argentina cable provider Supercanal S.A., and the 53 billion Chapter 15 of Pepco Frontera, Colombia's largest oil and gas EP company. Ron previously served as Vice President for International Affairs of the American Bankruptcy Institute and on the Board of Directors of Insol International. He also wrote the Chapter 15 primer for a leading treatise. Thank you, Ron, for being here with us today. Our next panelist is Robert Wagstaff. He is a recognized expert in Latin America and has 30 years of career, including over 20 years of experience in the restructuring, transaction, and assurance advisory space, during which time he has led and executed engagements in every major country in the Americas. His technical expertise includes turnarounds, financial restructurings and divestitures, buy-side and sell-side financial due diligence, merger integration, business viability evaluations and valuation. He has also held senior financial and operational positions in the private sector. He is fluent in Spanish and French and has a thorough understanding of written and spoken Portuguese. During the past decade, Robert held senior positions in the corporate finance practices at Berkeley Research Group, Frontera Capital Advisors, and FTI Consulting, leading complex restructuring and M&A advisory engagements in Latin America and in the United States. Robert, welcome. Our third panelist is my distinguished friend Juan Luis Goldenberg, who is currently an associate professor at the Pontificia Universidad Catolica de Chile in both civil and commercial law, and acts as off-counsel of a law firm Barahona y Cia, where he has specialized in advising both local and foreign companies in financial and insolvency issues. He's also the executive vice president of the Ibero-American Institute of Insolvency Law and president of its Chilean chapter. He graduated from Pontificia Universidad Católica Chile in 2001, was awarded a public scholarship in 2007 for his doctoral studies in Spain, and graduated from Universidad de Salamanca in 2010 with a thesis on subordination agreements. Between 2010 and 2011, he worked as an international associate with White & Case LLP London branch, specifically in the area of financial restructuring and insolvency. He has acted as the legislative advisor to the Superintendency of Bankruptcy regarding the discussion of the new Bankruptcy Act, and then worked for the new Superintendency of Insolvency in the creation of a new institution and training of the Chilean courts. So I thank you very much, our panelists, for being here with us today. And without further ado, Manuelita, I would like to go on with our questions to our panelists. And I guess the first and most obvious question is, why would a Chilean debtor company consider submitting to insolvency proceedings in the United States? Robert, perhaps you can give us some light on this very basic question.
Yeah, sure. Thank you. And good afternoon, everyone. Muy buenas tardes. Two things come to mind in general in answering that question. First, for better or for worse, there is a large volume of case history in the U.S. That has been litigated in the bankruptcy courts and satisfied through the bankruptcy courts. So in a sense, that gives the debtor a certain pathway to develop guidelines for considering their options and assessing potential outcomes from their filing. I wouldn't say predictability, but it injects a level of comfort in terms of how the process will play out. There's a very well laid out process. There are very well laid out timelines. There are guardrails in terms of decision making that, again, provide a level of predictability and a level of comfort to the stakeholders involved in the process. Interrelated to that, in the US, and partly because of the transparency of that process and the large volume of case history, there's a robust financing market that debtors can attempt to access as part of their reorganization plan, which may or may not exist in other countries where those protections may not be either afforded or enforced or even available to people willing to invest during the bankruptcy process. When I look at a case like LATAM, for example, the case history, I think for them was very informative in terms of them laying out their initial strategy coming when they filed. Avianca had just filed, and there are administrative issues that they could lean on from there. There was multiple filings in the last decades through a couple of crises in the airline industry in the US. They can glean information from that. In this case, a very particular industry where you've got complexities around movement of funds intercompany across multiple jurisdictions that require guardrails around it. There are derivative contracts and very sophisticated leasing arrangements that, again, folks can lean on, and for any industry, frankly, find information to help them guide their strategy during the process.
Thank you, Rob. And Juan Luis, in addressing this very fundamental question, what's your experience or your views from the Chilean perspective?
Well, thank you very much for the invitation first. I think that from the Chilean point of view, even though we have a new regulation, insolvency regulation, since 6 years ago, and there has been some improvements on the reorganization structure, of course, it is not prepared for very large and complex companies. The superintendent of insolvency said a couple of days ago before the Congress that our regulation is very good for medium companies, but not for large companies. And I think the main factors for that are first, how long is a reorganization proceeding in Chile? Because in Chile, the longest proceeding might be only 100 days. So it's a very, very short period for having time for negotiating the terms of a plan. If it's a very complex company, it's going to be almost impossible to get the specific terms that are useful for a reorganization. And second, it's very difficult to articulate a very complex fresh money structure. Rob was talking about this very robust financial market in the US, and we don't have that. So if the company needs money, real money for continuing its operation, it's going to be very, very difficult to have it. And also because of the time frame, it's going to be almost impossible. And also because in these large companies, most of the creditors might be abroad, so they will not feel very comfortable coming to Chile because it's not a very known insolvency scenario. So all the experience that the US Chapter 11 has, it's much more attractive.
Right. Thank you, Juan Luis. That's very illuminating. And I guess it leads us to another question that I would like Ron to address, which is what we're seeing here is that a reorganization is a complex process. And what you're saying is that the more complex it is, the greater the incentive to move to the United States, where we have Chapter 11. But it could also be the case that we have a restructuring in Chile that we would like to have an impact, at least in the United States, if not around the world. And I guess that leads us to the difference between what is known as Chapter 11 and Chapter 15. Ron, can you give us some light on this? Because it sounds very technical.
Sure. Thank you, Guillermo. Let me just make a couple preliminary comments that play off of what Juan Luis and Robert had mentioned in terms of why would a company want to utilize Chapter 11, particularly if they're not based in the United States. As they alluded to, two of the significant factors are that in the United States, the bankruptcy courts are specialized courts. They hear only bankruptcy cases. So you do not have the situation that is in many parts of the world where the judge will, one day hear a contract claim, one day a criminal claim, or an trusted estates claim. The bankruptcy judges in the United States all day, all night hear only bankruptcy issues. So they developed some predictability and expertise. The other significant issue is if a company has significant creditors with contacts and business in the United States, and many because of the size of the United States and its economy, many good-sized companies around the world, even if they're not based in the U.S., will have contacts with the U.S. In that case, the order of the U.S. court will have the pragmatic effect of binding those creditors and those parties. They will not want to risk disobeying a U.S. court order. So the practical reach of the United States is important to some companies in restructuring their debts. With respect to Chapter 11 and Chapter 15, there is a significant difference. Let me speak briefly about Chapter 11. I think many people have heard of Chapter 11, but Chapter 11 is the main reorganization statute in the United States, and it provides many tools for companies to reorganize. Companies through Chapter 11 can terminate ongoing contracts that they're not allowed to under normal state law. They can sell assets. They can obtain a stay of creditor remedies, so they have a breathing space to try to reorganize when their liquidity is low. And then, of course, ultimately, under Chapter 11, the culmination is that there would be a plan of reorganization. Creditors would be entitled to vote on that plan, and there are standards for the court to approve the plan. But ultimately, under Chapter 11, the U.S. Bankruptcy Court will approve a restructuring and reordering, including over the dissent of minority creditors, if standards are satisfied, of all of the indebtedness or the targeted indebtedness of a company, and give it a fresh start and a discharge of its old debts. So that's a significant benefit, but it's a significant and a complex process. However, not every company needs or wants that extensive procedure in the United States to reorganize its debts. Chapter 15 is our bankruptcy law that is we call it our ancillary, our assistance, international assistance bankruptcy chapter. And that's the chapter where a company in a reorganization proceeding outside of the United States can come to the United States for targeted, select help without the necessity of opening up the full Chapter 11 case and all the requirements that entails. And there are really two principal uses of Chapter 15. The first is to get interim protection to stop creditor remedies against a company's assets in the U.S. And the second is to obtain U.S. court approval of the reorganization that will be ordered in the main or the foreign proceeding. In this case, in a Chilean proceeding, if there is a reorganization and the company wants to ensure that that is respected in the United States, under Chapter 15, you would come to the U.S. Bankruptcy Court and ask for the Chilean reorganization plan to be enforced and respected in the United States. And that's a streamlined procedure.
Thank you, Ron. And that makes me wonder how difficult or how easy is for a Chilean company that is seeking a complex reorganization where, as you have mentioned, there are multiple factors to be taken care of, and it decides to go to a U.S. court and seek protection to negotiate a reorganization plan under Chapter 11. Is it easy to get it? What are the requirements?
Sure. Surprisingly to many, the requirements for a company to undergo a Chapter 11 proceeding in the U.S. are very low. The requirements are that a company has its domicile, i.e. be a U.S. company, but that is not required. There are alternative requirements, unlike many countries around the world. If a company has either a place of business or assets in the United States, and those can be very small amount of assets, it will be entitled to file for Chapter 11. I think we have a bit of feedback. That sounds better. Thank you, moderator. So it is the technical threshold for a U.S. court to have jurisdiction over a company in Chapter 11 are very low, and there's no minimum level of assets. So it has been the case that even a small bank account opened in the United States or a retainer in the attorney's bank account can constitute sufficient assets. It's also possible that a judge can decide that although he has jurisdiction over the case, upon various factors, the judge may decide that the case is better off to be dismissed, or he should abstain from that case, perhaps where there are alternate proceedings going on and litigation going on elsewhere. But the requisite level is very low.
Thank you, Ron. And that obviously makes me ask Juan Luis, what's the Chilean side on that very issue? Can any Chilean company that is eligible for a Chapter 11 proceeding reorganization be admitted by the local courts and will be validated by the Chilean courts, or do have the creditors in Chile have any saying on whether a Chilean debtor wants to move to New York to try its case?
Okay, I think that if the company chooses to go to the Chapter 11 in the US and he's admitted there, what would happen is that in most of the cases, but not in every case, they would try to get that foreign procedure recognized in Chile. And in Chile, as from the new insolvency regulation, we have incorporated in our law the Cross-Border Insolvency Model Act of the UNCITRAL. And that means there is a very speedy way in which the Chilean court can recognize and enforce the terms of the foreign proceeding. For that purpose, it's only required that the foreign representative of this foreign insolvency proceeding comes to Chile, shows that there is an insolvency procedures abroad in the Chapter 11, and that he has been appointed as the foreign representative. That's the only thing he has to do. So it's very, very simple. In case it is a debtor in possession structure in the US, it's the same company that's going to come to the Chilean court to obtain such a recognition. What could be a matter of discussion with the creditors would be if they intend to show that the center of main interest, the COMI, is located abroad, so that the foreign procedure is considered as the main proceeding, meaning that it's the proceeding that is supposed to lead on the managing of the insolvency, and the Chilean court will act only as an ancillary court, as Ron was discussing with the Chapter 15 in the US. In such case, what you should see is that the law incorporates a presumption, a rebuttable presumption, that the COMI, the center of main interest, is where the registered office is. But as it is a rebuttable presumption, you can prove that the main aspects of your activities, your main assets, your management, your main creditors are located abroad, so that a third party may think that the one or the people they have to deal with, it's not located in Chile, it's located abroad. So, for instance, in LATAM, this was a very big issue because, of course, you would initially think that LATAM is located in Chile because the registered offices are in Chile. But they went through this rebuttable presumption and rebutted it and said that the center of the main interest is abroad. So the Chapter 11 will be the leading insolvency case. So regarding your question, I think no, that the creditors cannot, at least in Chile, cannot say that the company cannot go to the US. Maybe there's a discussion that they may have in the US, but in Chile, the limitation is only very formal. They can prove that there is an insolvency proceeding, that they are the foreign representatives, and a discussion regarding the COMI.
Right. So thank you, Juan Luis. Rob, I would like to turn the focus now on the preliminary phases, in the sense that I, as a counsel to any large company that is finding it difficult to deal with its financial obligations, let's put it that way, you would normally engage in voluntary discussions with the banks, with the creditors, with the bondholders, in order to achieve some kind of voluntary or out-of-court type of arrangement that will give them enough space, breathing space. But at the same time, I know my client will be talking to someone like you and will be entertaining discussions about the possible alternatives to a voluntary reorganization. What are the financial drivers of this thinking process? Where is the tipping point when we move away from voluntary restructurings into a reorganization plan?
Maybe addressing the tipping point first, I think it depends on the case, but the overriding, I think, practical financial consideration for the debtor is, at the end of the day, will the cost of the case, and we'll learn later on all the professionals involved in the case that are primarily the financial responsibility of the debtor during the case. If the cost of administering that case is outweighed by the benefit of, or the intended benefit of the filing, meaning is there an ability to restructure their balance sheet to the point where it's worth the disruption, the distraction, and the cost for the debtor to enter that process. It is not uncommon in Chapter 11 cases that they also begin with out-of-court consensual restructuring negotiations. Sometimes those play out favorably. Sometimes they don't. Sometimes there are unforeseen precipitating events like COVID-19 that force debtors like Ltda, Mavianca, and other industries particularly sensitive to this virus phenomenon to make more accelerated decisions. But so the cost benefit analysis, I think, is the overriding one. And then, getting into the weeds a little bit more in terms of planning for a filing, there has to be a real assessment of the criticality of vendors and the customer base, and how the debtor plans on dealing with them within the guidelines and restrictions of the bankruptcy code. They need to take a hard look at the relevance of the current assets and whether or not they are pertinent to the ongoing operation of the company during and upon exit from bankruptcy, and whether or not it's more appropriate to find a way to monetize those assets, again, within the restrictions of the court. But the cost benefit in terms of what the desired outcome is and what the company would look like from a balance sheet perspective going forward post confirmation of the plan, to put them in the best competitive light. That's the overriding financial consideration.
And Ron, let's assume for a minute that the advice is that they should go for a reorganization process. Who are the key players in here? Can you give us a little light on the battlefield and who does what and where?
Sure, thank you. As Rob rightly said, there are a lot of players, important players in a Chapter 11 process. And as I mentioned earlier, Chapter 11 is a very complex and a powerful tool, but it is an expensive tool. And perhaps there's two main drivers for that. First, in the Chapter 11 system, the policy view of our reorganization law is that management should stay in place in Chapter 11. There's not an immediate trustee put in place, as there is in many countries around the world. There is the possibility for a trustee to displace management if fraud or other impropriety by management is shown, but the norm is that management stays in place. In order to provide, because the view is that will be more efficient, the management understands the business and is more likely to reorganize than to liquidate. In order to provide a protection to creditors, the law also provides an official committee of creditors to be formed by an entity from the Department of Justice. In order for that committee of creditors to be effective, the law also provides that it can retain its own professionals, lawyers and bankers and financial advisors, and they will be paid from the assets of the debtor. So that obviously results in a situation where every action that the debtor takes that requires court approval in the U.S. can be met with creditor questions and opposition, and will be, at least review, because there is a creditors committee designed to do that. That adds to the expense. The second area of expense and complexity from the U.S. Chapter 11 perspective is that almost every action that a company takes during Chapter 11 that is out of the ordinary course of business, i.e. not flying planes in the case of an airline business, but buying or selling assets, entering into extraordinary contracts, raising money, things that are outside the ordinary course of business require court approval. that requires a separate application every time the company seeks to do something like that. And every time the company seeks to do something like that, creditors and the creditors committee can have a view. They can speak, they can be heard, they can conduct discovery, and they can challenge, or they can cooperate and approve. But those two things together add for a complex process. So the creditors committee and the debtor are two of the most important parties in Chapter 11. Often a third is the lender, because they will often have security and have special rights and may provide post-bankruptcy additional lending that gives them special rights and negotiated rights in a Chapter 11.
Right, and let's now turn around the focus on what is our debtor company seeking. Essentially, our debtor company, what is seeking is relief, some kind of protection, and principally, I think what it is that we're talking about is a stay, i.e., stop creditors from enforcing their rights, from foreclosing on their collateral, so to give room for the company to reorganize and to plan. How is that, and I guess this question is for both Rob and Ron. I would ask Rob to address from a financial point of view, whether the stay is sufficient or something more is needed in order to effectively work out a reorg. And to Ron, what are the jurisdictional aspects of the stay, and if you can effectively stop everything going against the company during the stay, and for how long can it last?
Well, from a financial perspective, in terms of the sufficiency, again, I think in large part it'll depend on the mix and the jurisdiction of creditors. By and large, most U.S. creditors would fall under the stay protection of the bankruptcy court. But again, in the assessment of the critical nature of certain vendors, the debtor may look for exceptions and ask for permission to enter into special financial arrangements with those U.S.-based critical vendors. If a large portion of the creditor base is foreign, you get into the complexities that Juan alluded to, and certainly I'll let him speak as the legal expert to recognitions of those proceedings in foreign jurisdictions, where in many cases the thresholds for pushing a company into insolvency or liquidation are much lower than the U.S. So it is a delicate risk balance, and in a case where most of the creditor base is predominantly U.S. based, I would say the stay is sufficient in general. But when you get into a large amount of foreign creditors with large claims, it becomes a much more complex negotiation, which affects, again, the permissions that the debtor would ask of the court, which potentially affects the amount of financing the debtor would require during bankruptcy to satisfy some of those foreign claims that could potentially pose a risk of an involuntary insolvency, for example. So, again, it depends, but in general, those are the considerations.
Right. So, Ron, how much protection do we get when the court orders a stay?
Sure. So, one thing that's really illustrative about the stay that the Chapter 11 provides is that we call it the automatic stay. That is, that you do not have to ask the judge to provide that stay, which is an injunction against creditors seeking remedies. The mere fact of filing what we call the petition to start the Chapter 11 case, from that second that paper hits the docket, by law, there is an automatic stay of all creditor remedies against the debtor. And that covers secured creditors, unsecured creditors. It's very powerful. There are, of course, exceptions, and creditors for cause shown can ask for relief and permission to exercise remedies. But that's the exception. The rule is that there's an automatic prohibition on exercise of remedies against the debtor or its property. Furthermore, in ubiquitous U.S. fashion, our law says that our stay is extraterritorial. It applies anywhere in the world. Now, that is effective, as I said, if the creditor that's seeking to exercise the remedy is subject to the jurisdiction of the U.S. court. If it has assets or plans to do business in the U.S., it will not want to violate that order. However,
Right.
if the creditors do not, then there's a pragmatic effect. It is very nice what the US law says, but if it cannot be enforced outside the US, it's a practical matter, then it will have limitations. And I think, as Juan Luis will say, fortunately, Chile has our equivalent of Chapter 15, but in many other countries they do not. So there is a question of being able to enforce the stay outside the US.
Right. So, Juan Luis, what do we do here in Chile with the long arm of U.S. law? And in particular, I would like you to address something that is very important for many practitioners here in Chile, which is what happens with derivatives.
Okay, I wanted to say something because it might be funny, but the Chilean law also provides for some kind of automatic stay. It's called Protección Financiera Concursal, and it's also its purpose is also to be extraterritorial anywhere in the world. And of course, we might have exactly the same problem. But I think it's a matter of size or an importance. I think I would never tell a client that has any kind of business or any kind of relationship with the US to do something against the automatic stay, even though they are located in Chile, because they are going to have a very, very hard time in the US when they try to do anything over there. From the Chilean point of view, in order to extend the automatic stay, you should go through the recognition that I was talking before, through this Chapter 8 of the insolvency law. But I have to stress something. It is not that the automatic stay is fully recognized under the same terms as it has been granted abroad in the US or anywhere. The effects of the recognition are set directly in the Chilean law. So you would have to go through the Chapter 8 and understand if the foreign proceeding is considered as a main proceeding and there are some effects, or if the foreign proceeding is considered as a non-main proceeding and there are other effects. In most of the cases that we have seen in Chile is that the foreign proceeding is the main proceeding, so the effects are mandatory, and the effects are the suspension of individual proceedings or claims from the creditors, the suspension of any execution over the debtor assets located in Chile, and of course, a suspension of the right to transfer, to encumber, or otherwise dispose of any of the assets of the creditors in Chile. So, even though it might be the case that in the US there's any kind of restriction on the derivatives, in Chile you would have to go through these specific limitations, and there's no specific limitation that refers to contracts. So in general, at least from the Chilean point of view, you would not have any limitations on the termination of the derivative or the closing of the derivative, not at least under Chilean law. You would have to do it through the US law. There has been, you can see some exceptions on this stay based on a limitation that our law recognizes, that is a limitation on public policy. The Chilean public policy, meaning both the substantive public policy or the procedural public policy. So, for instance, even though the relief includes the suspension of some kind of lawsuits against the company, for instance, or for example, it does not apply for labor-related issues because Chile believes that that is a main part of the public policy.
That's interesting. So essentially, labor claims are shielded, are protected from court orders that would stop them from suing and filing for their claims. That's very interesting. Ron and Rob, Chilean potential filers would normally involve large Chilean companies that have either issued equity in the form of ADRs or be debt in the form of registered bonds or 144A bonds, but essentially there are lots of securities issued by these Chilean companies that may one day have to seek a reorganization plan through Chapter 11. Is there anything special that happens upon filing of a Chapter 11 with these securities? Do they continue to trade normally? Does anything change from the point of view of an asset manager who's sitting on these bonds or these ADRs?
The short answer is no. In most cases, nothing changes. It's business as usual, and depending on the industry and depending on the size of the company and depending on its location, there may be a very robust secondary market during a bankruptcy proceeding. We're advisors to the government of Puerto Rico. We've been doing it for 6 years, and certainly there is nonstop investing and divesting in those bonds as the government goes through this elongated process. So, I mean, it is possible as part of a debtor in possession financing vehicle that some of those securities may be offered up for exchange to recapitalize the company. But in general, they're free to continue trading as they have been pre-filing.
Okay, and there are no class actions or special claims because our company went into default and sought protection. There wouldn't be any issue with that, or
Well, there.
Go ahead,
Robert. So there can be. I mean, parties are allowed to sue and companies in Chapter 11. They need to receive permission to do that, and they can file claims. Interestingly, with respect to equity securities, because under the Chapter 11 law, creditors must be paid before shareholders, equity holders. The law provides that claims by equity holders, even though those might be damage claims, they are subordinate. Those claims, even if they have damages, will be subordinated and relegated to below the level of the creditors. So equity security holders who have been harmed or defrauded are entitled to bring claims for damages, but they can't sit pari passu at the same level with creditors.
Right. Ron, you raise a very interesting point, pari passu. One of the more controversial issues that has arisen in connection with the LATAM Airlines restructuring was the debtor in possession and certain convertible securities, i.e. means pursuant to which the company was seeking to raise new money. What are the intricacies of this financing that occurs during the filing process? Do they stand pari passu with all other creditors? Do they stand better? Is there anything that is driving this process of raising funds either via equity or debt during the process?
Sure. Let me take that from a bit of a high level, and I know that Robert's got some interesting experience on that I'd like him to share. So one of the significant attractions of Chapter 11 is that it does permit a company to raise additional financing that is senior, in certain cases, to existing secured financing. And that is something that in the United States cannot be done outside of bankruptcy, what we call priming, elevating above existing secured debt. The law does provide that. There needs to be stringent showings that it's necessary, and that the existing secured creditor will, what we call, be adequately protected, meaning the value of its security will be protected. So either there's other collateral that it can receive, or that there's an equity cushion. Its debt, i.e. its debt is not as great as the amount of the collateral that it has. But the law does provide for senior secured priority financing under Chapter 11 where it's not otherwise available.
And then I think in general terms, in terms of super priority, other than this priming, in the recovery stack, the debtor in possession financing is above all administrative claims and other secured claims in terms of recovery. So it is pretty attractive protection, as I mentioned from the beginning. And And look, the reality is, in rare cases, do debtors go into a bankruptcy with enough cash on hand or with the expectation to generate enough cash during the process to not require some sort of financing to get them through to exit, right? So the debtor in possession mechanism is tried and true, again, very, very robust, with a robust set of protections for the investors. One of the other financial considerations is the sizing of that facility on the part of the debtor. In many cases, the debtor will seek liquidity or in excess of what their needs might be. And part of that is strategic in terms of giving confidence to the vendor base and the customer base that there will be enough liquidity on hand so that the vendors can continue to supply and the customers can continue to contract and do business with the debtor during the process. So it is an extremely common vehicle in almost every case. And Ron, I can't think of one, frankly. The DIP facility is structured as some sort of asset-backed loan, or Ron's point, if there isn't enough collateral, a priming loan. It is, during the summer, Hertz actually tried to take advantage of the euphoria in the stock market during their initial proceedings to actually supplement the DIP financing with, I believe, was $1 billion of a common stock issuance. And the securities regulator stepped in to stop that plan. Obviously, with little to no protections for those investors, it was an aggressive plan, but one that ultimately did not pay off. And again, I'm not aware of any junior equity issuances as part of a DIP financing that has been successful in the Chapter 11 case.
That's very interesting, and I was hoping that Juan Luis could tell us from a Chilean perspective. We have our prelación de crédito, which I believe is a norma de orden público, i.e. mandatory. How does it play with these super protections and super preferences that we're hearing from our colleagues in New York?
I think this is a very, very, very hard question. This is what I want to say. First, because there has been no case law whatsoever about this topic. And second, is something that one of my students once asked me in a lecture, and I was like, well, I do not have a ready answer. But I have thought about it, and I think there are two issues that must be considered. First, that the new Chilean Insolvency Act provides for super priority in case of post-petition financing in Section 74. So it is not against the public policy of the Chilean public policy to grant such kind of protection, special protection to any form of financing throughout a reorganization proceeding. The requirements are very different. In Chile, the requirements are very low to get this kind of protection, but the protection is very high because this kind of credit will rank over workers, over tax claims, over secured creditors, over almost anyone. So I think we would recognize that kind of priority, super priority. And also, because if you look at Chapter 8 with the cross-border insolvency rules, there's a provision, that's provision 312, that says that in a Chilean insolvency proceeding, even though the claims are foreign claims, they will rank accordingly to the Chilean prelación de créditos, ranking of credits. So I think as that rule is part of this cross-border model law of the UNCITRAL, as Chilean, we should be prepared to see that the same law exists in other jurisdictions. So if it is a rule, for instance, that in the US, the claims, even the foreign claims, will be ranked according to the US law, I think that Chilean courts should be fine with that. And
okay.
Respect, of course, the super priority on the financing.
Right. I would like to ask to our three panelists something that probably is in the minds of our friends here who are attending the webinar, which is now our company has filed for Chapter 11, so everything is in motion. We are negotiating a reorganization plan, and we want to. And I I think we all want to know what happens with the board of directors. Do they continue to run the business? What is the role of the creditors committee, Rob? What kind of powers do they have? What can they do or not do? And Ron, very significantly, what is the role of the judge here? Is it a passive judge? Is it an active judge? And Juan Luis, all of these that is going on in New York, and depending on the response of our colleagues in New York, how is the Chilean law responding to probably changes in the way that the company is normally run, in the way that creditors normally have a relationship? So I guess, I don't know, Ron, Rob, who wants to take the first one?
So just from a governance perspective, in most Chapter 11 cases, governance would remain unchanged. It's possible that a temporary officer could be appointed to the role of chief restructuring officer. That person would typically be someone from the financial advisor group that was hired by the debtor to participate independently in major decisions of the debtor. But other than that, the management and the governance typically stays in place. As Ron mentioned, they effectively assume the roles of a trustee and have fiduciary responsibilities and duties to carry out during the bankruptcy case, and restrictions about decision making that they can do without accessing the courts. But from a governance perspective, things typically don't change. As it relates to the creditor committee, they are appointed by the U.S. trustee, typically within 10 to 14 days of the filing by the debtor. The trustee will post a solicitation form where creditors are invited to solicit their participation on the committee. The trustee will make a determination as to whether a committee is appropriate or not, and if so, will typically appoint an odd number of members of creditors who have solicited membership to sit on the committee. Committee members have a fiduciary responsibility to protect the interests of all unsecured creditors. They will also typically get involved in negotiations with the debtor and other groups. For example, if there is an ad hoc group of creditors that's formed, they become a very important party and interest in the case, and the committee and their advisors would typically look to work with them for a satisfactory outcome. The committee is responsible for hiring their own professionals. In many cases, committee members will also have their own counsel to protect their risk and mitigate their risk in relation to carrying out their responsibilities. And in some cases, which we can get into, the committee may be in a position to propose an alternate reorganization plan if the debtor's exclusivity has run out and they have not been able to confirm a plan of their own. So they are very serious and very broad responsibilities that the committee takes on, and they're an integral part of the process.
Ron, so what happens with what's the role of a judge here? What are the powers of a judge? Can he address to different constituencies, or does the court have to look at the creditors as a single group and negotiate a reorganization that applies to everyone in the same terms and same conditions, or the judge can start being more proactive in segregating and sub-segregating groups? Please give us a light on that one, because we're really interested to know how this plays along.
Thanks, Guillermo. That's a particularly insightful question, particularly for a cross-border audience. In my experiences, in many civil law countries with a civil code, the discretion of the judge can be relatively limited. The law says X, the judge applies the law according to X. In some common law jurisdictions, and particularly in the United States in our bankruptcy courts, there's a great deal more discretion that the judges have in applying the statutes. There are less bright line tests and more areas of discretion. So it's particularly important to understand the relief that a company needs. And a particularly insightful aspect, Guillermo, of your question is, where in the United States should a company seek Chapter 11? Our statutes do provide the ability in some circumstances to file in different cities if you are a company. And our law, though we have one uniform national bankruptcy law, we have different bankruptcy judges in 50 different states and more than one bankruptcy judge in each state. And not all of them, because they have discretion, not all of them rule the same way on the same issue. So it's very important to understand as a practical matter the relief that one needs as to where they're going to file and which judges rule in which fashion and which judges are more active and more proactive and which judges take a less proactive view. So particularly from a cross-border perspective, that's a really great question.
So Juan Luis, I think that all of that we're hearing from Ron and Rob is kind of novel to us. How does Chilean law accommodate for these cross-border interaction between a court in the US that is trying or entertaining this reorganization sponsored, court-sponsored plan, and the Chilean court that probably is entertaining other claims of this against the same debtor? Can you give us a little light on that one?
Yes. Regarding what Ron was saying, of course, in Chile, we're very used to have a very, very silent judge. Meaning that a judge will never, ever go through a review of the economic terms or the needs of the company. The judge is just there to solve any kind of a legal dispute among the parties, but nothing else. So if in the US, the judge has a lot more discretion to act and to take some decisions and to approve certain activities of the companies or not approve certain activities of the company, from the Chilean point of view, this sounds very, very strange. However, if you look at the cross-border insolvency regulation in Chile, there is a possibility of the foreign court to coordinate any kind of actions with the Chilean court. This part of the law has never been implemented. There has never been any kind of coordination during these 6 years. But in the case of LATAM, there was set up some kind of protocol to be used just in case. It has not been used, but it could be used. And this was a proposition of the Superintendency of Insolvency to say, well, what has happened usually is that in the other cases, the judge, the Chilean judge, just recognizes the foreign proceeding and grants the relief, and that's it. But as in this case, it's much more complicated, and there are much more Chilean creditors. There has been set up some kind of protocol to help the foreign judge in case it's required in Chile, but it has not been implemented yet.
Thank you. Thank you very much, Juan Luis. I know, Rob, you have to run to another meeting, so I don't want to lose you before I make you this basic question that it's probably in the minds of our audience. How long and how difficult it takes us from A to B, A being the time of the tipping point when the company, the debtor, decides to go through this process, and we get a final approved reorganization plan that will solve the problem. How long, how complex? What's your basic experience in that?
So there are prescribed timelines within the statutes, and in general, from the first day of filing, when the debtor would submit its voluntary petition along with some summary financial information and a declaration from an officer of the company explaining the facts around that led up to the filing, explaining their plan for emerging from for managing the company during filing, and other relief they may ask from the court around the use of the estate's assets, any specific considerations, for example, around derivative instruments during the period. So from that day, the next scheduled date is 15 days from there, where the debtor is required to submit what are called their statement of financial affairs, which is a much more fulsome disclosure of financial affairs, including payments made to third parties the 90 days leading up to filing, which could be subject to scrutiny, payments made to insiders in the year leading up to the date of filing, which again could be subject to scrutiny, and then what's called the schedule of assets and liabilities, which, depending on the breadth of the company, could be a massive undertaking to list out every single known and contingent specifically liabilities, and then schedule of assets the company is under possession and filing. Typically, in a larger case, the debtors will get relief and get extension to supply those schedules. Again, given the nature of them and the breadth of them. In the meantime, there is typically a scheduled meeting of creditors that the U.S. trustee will schedule, and that happens sometime between 30 to 45 days from the date of filing, which will enable a forum for the creditors to ask representatives of the debtor, based on their declarations, specific questions about the case. And then the next important milestone is, I referred to it before, is 120 days from filing is the initial exclusivity date during which the debtor has the exclusive ability to propose a plan of reorganization. Again, in most cases, that date is extended in LATAM and Avianca and Aeromexico because of the uncertainty of the climate that they're operating in. They all received extensions of that date. LATAM is now 240 days, if I'm not mistaken. So that 120-day milestone or 4-month milestone then begets a 180-day expected kind of plan acceptance date. My experience is that that takes us through 180 days and plus some notice periods and like. But my experience is 9 to 18 months is general window for a Chapter 11 case to get through the confirmation stage. Obviously, the implementation of the plan post-confirmation can take years and years, depending on the nature of the claimants and the obligations that need to be fulfilled post-confirmation.
Right. Thank you. Well, I'm afraid that we are running out of time. I have tons of other questions to make to our panelists. You've been great. So I would like, Manuelita, if you don't mind, to leave the next 5 minutes before our panelists have to leave for questions from our audience. I'm sure you have many questions from the audience, and I would like to give them the opportunity to talk to our panelists.
Thank you so much, Guillermo. Thank you, everyone. I had formulated a question which Robert just answered, but I do have a question of my own, and that is, we've highlighted all the benefits for a debtor to be able to do this procedure, and it must not come. That decision must not come easy. The explanation has been that it's a fairly easy process, and that as it's done, it's automatic, that the creditors are put on hold. I have to think that there's a negative side to going through this process, and you know, if anyone can give me some of that information, what are some of the negative side effects, if you want to call it, of filing for Chapter 11 for a company?
Yeah, I'm not sure I would use the word easy, but yeah, there are definitely prescribed procedures. But on the negative side, given all the stakeholders in the case, if there are objections to relief that the debtors seek and the counterparties cannot arrive at a solution, it is possible that matter could be taken into what's called a contested hearing, which is in open court. And in preparation for that contested hearing, there would be depositions that would be required, and all of these, of course, under the auspices of the U.S. court and the threat of perjury for making false statements. So there is the practical reality of potential litigation during cases that exposes people to uncomfortable situations, to potential risk that they may not understand. I think that would be. And again, the cost, the distraction to the business, I think those would be some of the deterrents or some of the considerations on the negative side for debtors to consider as they're evaluating that option. I don't know, Ron, if you had anything else to add.
Yeah, I would just add to that it is a huge strain on the business, because in addition to trying to actually run the business, Chapter 11, although it provides a lot of tools and options for a company, it imposes a lot of requirements in, as Rob said, in assembly and dissemination of information. There's a lot of transparency. Parties are allowed to make inquiries about the company that they otherwise could not. But there's also just a lot of information that has to be supplied to the court every time it seeks relief, and it's a huge strain on the company. The other thing that is important to consider is, particularly in a cross-border situation, some companies, can suffer a business fall off once they file Chapter 11. Their competitors use that against them right, to argue that they're not going to survive, even though Chapter 11 is a reorganization procedure. So all that has to be managed carefully with a public relations campaign, a financial advisors to help the company manage and carry its financial burdens, and as well as obviously attorneys to carry forward the relief they're asking for. But although it can provide a huge amount of tools and also impose restructurings upon creditors that are recalcitrant, there's a lot of distraction expense along the way.
Thank you. And I just want to ask something that is in a simpler terms, I guess, for the general public. When you hear of a company filing for Chapter 11, there's a lot of kind of simple questions as to for the consumer. What does this mean if I have a flight arranged for 3 months from now? Does that mean the planes are still flying? There seems to be a lot of confusion in that way. Are they going to close their doors for business? Are they going to keep running? Is it business as usual? It's not something I really have to worry about. That seems to be more of a image kind of problem than maybe you guys can clarify that a little bit.
I guess I would just say briefly, the company wants to continue its business. Without its business, the restructuring is meaningless. So the companies will certainly, particularly airlines, will certainly intend to make the Chapter 11 transparent and not affect the ongoing business of the company with respect to its customers and vendors. It's one of the main reasons why bankruptcy financing is so important. The companies want to show that they now have new, more than adequate amount of financing so they can carry them through their reorganization process.
Yeah, in the case of LATAM, you'll see through the public filings that they specifically referenced, customer refund obligations, the intention of maintaining the frequent flyer programs, specifically to address those types of concerns. Now, granted, the normal consumer wouldn't know where to find those filings in the public dockets, but so it needs to be supplemented with a public relations campaign. But as Ron said, it's a reorganization attempt to reorganize, and the customer's at the core of that recovery. So,
great, thank you so much.
Mm-hmm.
And I know, Robert, you're a hard two, which we've passed. We appreciate all of your answers, and I don't know if the audience has any more questions. We do have
We got 2 more minutes.
We got 2 more minutes. Wonderful.
Yeah.
Well, we have
there was a question, Francisco Fontaine. If the company fails to meet the requirements during the Chapter 11 process, which is the sanction? Immediate bankruptcy? What happens if this doesn't work?
Ron, you want to start with that one, or you want? It's a great question. Chapter 11 is a little bit forgiving. The company gets more than one shot at a reorganization plan. If the plan doesn't meet the requisite vote or not approved by the judge, the debtor is allowed to try again, renegotiate a plan, formulate a different plan. Ultimately, if a plan is not going to be confirmed, then the case can be converted and changed to a liquidation. But the courts give a lot of leeway for debtors to try again.
How firm is the reorganization plan when approved? Can there be instances where the approved plan can be challenged, or could there be an appeal, or is it good for?
Yes, just about any judgment in a U.S. court, a confirmed plan is an order, and it is a judgment, and it can be appealed. An important thing that's unique to bankruptcy plan appeals is that there is a policy that supports finality. So the creditors and everybody will know that the restructuring is final. So there is a risk that on appeal, the debtor can say the appeal should not be heard because it is too hard, as we say in English, to unscramble the egg. Too many things have changed. We call that policy mootness. So there is a potential for your appeal not to be heard, but you do have the ability to appeal, particularly if you move quickly.
I think that we have overextended the availability of our panelists, and I can only thank you so very much, Ronald, Juan Luis, and Robert. Thank you so much. This has been very interesting. As I said, there are many more issues and questions that we have in our minds, and probably we'll have another opportunity to follow up on this ones.
My pleasure. Thank you for the invitation.
Thank you.
Thank you very much.
Of Guillermo, Ronald, Robert, Juan Luis, we thank you very much for your time. We've certainly learned a lot. And I agree with Guillermo. I think there's much more to learn, and we hope we can have you again with us. We appreciate your time today. And one last thing is the video will be available in our YouTube channel, NACCNY. For those of you who had to leave early or didn't have a chance to see it, or if any of you want to share it, it will be available. And stay tuned for some of our next webinars. And if you are considering becoming a member, we'd love to have you. If anyone else has any questions, you can send them to us through email. And with this, we're going to end the meeting today. And thank you again, everyone, for being here.
Thank you, Manuelita.